My name is Michael Hano. I'm the chairman of the Belgrade Appeals Board. It is December 16th, Wednesday, December 16th at 6 o'clock in the evening. And we'll begin our Appeals Board meeting. I would like to first call the meeting to order. And secondly, have a roll call of the board members that are present. I'll call your name and just announce yes or no that you're here. I guess you're all going to be here. Norma Blazer.
I'm here.
David Bonar.
Here.
Dave Bradshaw.
Here.
And Michael Hano here. Dick Bourne will not be here. He has internet issues. So under, excuse me, under with the quorum of 5 of us, I guess, we have a quorum. So we'll begin the meeting. Under new business, the first item I'd like to have us approve the minutes of the November 18th, 2020 minutes as written. Has everyone had an opportunity to review them?
Yes.
Okay, may I have a entertain a motion to accept the minutes as written?
So moved.
Second. Jay?
Okay. Thank you, Dick and Jay. All in favor, please announce your name. I'll call Norma.
Yes, I'm in favor. I'm Norma Blazer.
Norma Blazer. David Bonar.
Dave Bonar, yes.
Jay Bradshaw.
Yes.
Michael Hano, yes. Motion is carried 4-0. The next item on the agenda tonight is an appellate hearing. Consideration of appeal dated September 3rd, 2020, filed by Jeffrey and Carolyn Stiff, representative by Chris Neagle, Esquire, and related to a Belgrade building permit number 78-19, issued on August 6, 2020, Jody C. and Stephen C. Jones for a project at 326 Sandy Cove Road. At this time, I'd like to ask the town's attorney, Jim Katsiaficas, if he could make a statement as to a few ground rules and our jurisdiction as to hearing this appeal, if you would, please.
Certainly. Thank you, Chair Hino. My name is, again, Jim Katsiaficas. I'm an attorney with the law firm of Perkins Thompson in Portland, here tonight as the board's attorney. And let's go over a few ground rules. As the chair noted, this is an appeal from a planning board decision. The planning board decision was August 6, 2020. It was approving a shoreland zoning permit, and after the fact, shoreland zoning permit to Stephen and Jody Jones for their property at 326 Sandy Cove Road. And there also are associated findings of fact and conclusions of law that were adopted by the planning board on October 16, 2020. These appeals have been filed by Jeffrey and Carolyn Stiff and also by John Sutton. So there are 2 separate appeals. The board is going to conduct a hearing on each appeal. So the first will be the Stiff's appeal and then the Sutton appeal. In each instance, it's a public hearing, but the nature of what the board is doing is appellate, meaning that it is reviewing the planning board's decision. The Board of Appeals is not going through the shoreline zoning ordinance and deciding each criterion anew. It is looking at that decision by the planning board and determining whether, based on the record, whether there's any error of law, whether there's a lack of support in the record by substantial evidence, and whether there was any abuse of discretion. That's it. That's what the board is looking at. And so parties have submitted written statements, and we'll hear from the attorneys, no doubt, for each party, and from members of the public. But the issue is with regard to an appeal from the shoreline zoning permit, not from a plumbing permit, not from a septic permit, not from anything else. It's from the shoreline zoning permit issued by the planning board and supported by their findings of fact. It's an appellate hearing. No new evidence is to be presented. We are going to be arguing this case on the basis of the record of what was presented to and reviewed by the planning board. So no new evidence comes in, whether it's from the attorneys, from the parties, or from the public. We are simply looking at the record and seeing whether the planning board made the right decision as an appellate matter. The Zoom format's a little bit of a challenge to use, particularly since the town doesn't have a webinar format where you would promote panelists and control who's on. When several of us have our microphones open, background sounds can bleed in and make it really difficult for us to hear and understand each other. So the request is that if we're not speaking, if we're not being called upon, let's turn off our microphones. The moderator is the town manager, Mr. Wilson, and he can see who's raising their hand if they want to speak or using the raise your hand function. So let's do that. We're not trying to shut off debate. It's a public hearing and everyone will be heard from who has something to say. But we just want to make sure that we don't, that we can hear it, we can record it, and that it is audible and understandable. So we'll turn off our mics if we're not speaking. When it becomes time for deliberation, after the close of public hearing, that's a time when the board will be talking. So you'll see that the board's microphones will be turned on. All of the rest of our microphones will be turned off because that's when the board speaks. So those are the basic ground rules. I don't think there are any surprises here. We've discussed some of these before, particularly with regard to the type of review and when information will be provided and accepted this evening. With that, I'll turn this over to the chair to begin the public hearing.
Thank you, Jim. Okay, we'll begin the public hearing by, I guess, asking Mr. Neagle if you would like to go first.
This is Jeffrey Stiff, and maybe I'll say a few words, and my wife Carolyn will as well, and then we'll hand it over to Chris to actually present our case. I want to take this time to recognize how thankful we are of the appeals board and having the opportunity to be heard. And I know it's a big commitment of your time, and we thank you for being willing to do that. What we are really asking for is the town of Belgrade to properly enforce the shoreline zoning ordinance in considering the proposed 2018 Jones structure. We appreciate the board's willingness to take this seriously and the facts of law that will be presented by our attorney. But I thought if I would just introduce my wife, Carolyn, and she has a few words to say as well. So this is Carolyn Stiff.
Well, I also deeply appreciate the appeals board giving us an opportunity to bring this matter to appeal before you, and thank you for your time. And as a point of reference, I was born I was born in Lewiston, Maine, but raised in Hollowell, attended the University of Maine. So my ties to the state run deep, and that includes a long line of parents, grandparents, and extended heritage. So the state really is important. It's part of me and my blood. And and I've actually been out to Sandy Cove for over 56 years. My parents purchased property around 1964, and my family, we cleared the land and pulled and built, and so we have a long heritage and in this cove, and it's just a very special place to us, and preserving it in a way that has been preserved for generations is just so important. We cherish it and hope to have it truly protected in a way that our progeny can enjoy it much as we have as well. I do want to acknowledge that this has been a very stressful process for my husband and me, and we've always had very good relations with Sandy Cove members. We've socialized with all of our neighbors, the Joneses included, and have been guests at our house. And but this process, of course, has kind of limited that contact over the last few years. But we just so hope that that your board will just see the merit and rule in a way that supports the shoreline zoning requirements on that use permit of the Joneses. And now I'll turn it over to Chris.
Thank you both. Chris, you're muted.
Chris, if you
Yep.
look down the bottom left, okay, sorry.
Okay, now can you hear me?
Yes.
I apologize. For those that don't know me, my name is Chris Neagle. I am the Stiff's attorney. I have a law office in North Yarmouth, Maine. I was on the Town of Cumberland Planning Board for 12 years, so I have a firsthand knowledge of what it's like to sit in your seats. And again, I want to thank you for your time listening to this appeal. I assume you have received and hopefully read the memo I sent back in mid-November with the long story and several key documents. I'm going to go through it in some summary, and I hope you also got a separate memo today with a picture of the kitchen as it existed in the spring of 2018. I also want to acknowledge that there were several letters written by longtime residents in the area. I know that your town manager's done an excellent job of passing them on. So I'm not going to repeat what those people wrote, but I do, on behalf of the Stiffs, want to thank them for their views and their comments about how this new residence does not comply with the shoreline zoning. So I quickly want to review the players involved, so we're all on the same page. First, there are Stephen and Jody Jones. They built their residence in 2017 and 18 without a permit. They have been trying to keep it ever since, and I think it's noteworthy. As far as I know, they've never attended any planning board meetings or this meeting. Then there's the town of Belgrade, with a board of selectmen and a town manager and a staff that issues permits for construction. In this particular case, its representative was the code officer acting on behalf of the town manager and select board. So then there are the neighbors, the Stiffs. You've just met them. This new residence has seriously affected the privacy of their property because it's too close to the line and it's way too big and other things you're going to hear about. And I think it's important to note that they've been at every planning board meeting and this meeting as well. They're very concerned about it. The other two parties that are important here are both the planning board and the Board of Appeals. Now, I think Mr. Katsiaficas would agree, and he can correct me if I'm wrong, but both boards are independent citizen boards appointed by the select board, I assume, And once you're appointed, the only thing you are bound to do is uphold your oath to support Maine law and Belgrade ordinances. The select people, the town manager cannot tell you what to do or how to vote. And I assume most of you know that, but I only repeat it because at the planning board level, the town and the Jones were acting together, which made it very hard for the stiffs to get a fair hearing. So let me get into the issues. First, in the big picture, there were 3 big errors made that have never been explained for reasons I do not understand. Number 1, in April of 2017, your code officer, Gary Fuller, gave the Jones a permit to build a 1-story garage structure in the shoreland zone. Mr. Fuller did not make the Jones get the required planning board approval for any new construction in the shoreland zone on a non-conforming lot. I understand that Mr. Fuller is very experienced, but the question I would like to be answered is, how did that happen? Next big mistake. With a permit to build a 1-story garage, the Jones went out and built a 2-story residential structure with 3 bedrooms, bathrooms, and a kitchen. It's more than twice as big as the structure they applied to build. Now, how did that happen? The stiffs have never explained to the public how they could make such an egregious error. Now, the third big mistake was that when the spring came and Mr. Fuller went out to inspect the property built by the Jones, he didn't do anything. Didn't seem to surprise him, apparently, because he made no comment about the fact that what was built and what were applied for were 2 entirely different structures. Now, I think in that case, the code officer was not doing his job again. So, as a result of this, it was built closer to the stiff's property line than shown on their building permit application. It's built right next to the main entrance to the stiff's residence. And in addition to taking away a lot of their privacy, it totally blocks their view from the main entrance northwest towards Long Pond. So it's a serious problem. Jones had told the stiffs the previous spring they were going to build a garage. And when the stiffs came back and found a 2-story, 3-bedroom residence with a full kitchen and 2 bathrooms, they were understandably unhappy. And no matter how well the new septic system may work, adding a second residence on a narrow, non-conforming lot is not a good thing on a Long Pond watershed with poor soils in general. So we believe the planning board made errors of law. They made findings of fact that are not supported by the record. And that's why we're asking you. Excuse me 1 second, I've got to get rid of something.
Chilly for tomorrow, and Friday morning's going to start out chilly, but be able to stay warm up very lightly.
I apologize. I didn't realize the mute button on my TV had a timer. So anyway, I guess as the stiffs told you, what they would like the town of Belgrade to do is to enforce the Belgrade Shoreland Zoning Ordinance to protect the lake. I think it should demand that their code officer enforce the ordinance fairly. And I think it should do more to people who build structures totally without permission than assist them in getting a permit to correct their error. It just doesn't make sense to me. So let me quickly review the story. The story is in April of 2017, the Joneses builder, a gentleman named William Paradis, or Paradise, I don't know how he pronounces it, to build a 26 by 26 foot, one-story garage structure. And if you have my November memo, which I'd like you to have handy, because I want to talk about some of the exhibits, you can see in Exhibit 1 the permit that they received. And you don't necessarily need to see it right now, but it describes a garage with laundry / playroom. And from what I've heard, Mr. Paradis is a well-known local builder who's received many building permits from Gary Fuller. Again, what was built was a 2-story residence with a full kitchen, a playroom, bathroom, laundry room, 3 bedrooms, bathroom, covered patio. And hopefully you can pull up or look at the Exhibit 2 to my memo, which is a photograph of this new structure, looking down towards Long Pond with their the Jones primary residence in front. Now, I want to state the obvious. There's significant perspective going on here with respect to the 2 buildings. I think when you measure the square footage, their primary residence is actually slightly larger than this structure. But nonetheless, this is a good picture of what they described as a garage with a laundry and a playroom. And hopefully you got the email today with the picture of the kitchen. So there's a picture of the kitchen as it existed in the next spring. It was actually taken by Carolyn Stiff. She came back to her property to open it, surprised to see what was there instead of a garage, looked around, looked in the door from under the deck, and snapped this picture. Now, as you can see, it's a full kitchen. That's what they built, with no building permit for it. So, and I do want to note that as we consider the project today, the planning board has required that they take out the microwave oven and the refrigerator in their stove. But everything else you can see in this picture is going to stay, including the kitchen sink and the kitchen cabinets and the breakfast island. That's going to stay. So when the Stiffs found out about that, they talked to the town manager, and he told them he'd look into it and take appropriate action, and nothing happened. So the Stiffs had asked the town to look into it, but then they began to have some discussions with the Jones about possibly settling their differences privately. Those discussions lasted for almost a year, but in the fall of 2019, they broke apart, and so the Stiffs again asked the town to resume enforcement activities and to keep them informed. Surprisingly, in November of 19, the town and the Joneses privately and without any public notice or knowledge entered into a private settlement agreement whereby the Jones were going to be allowed to keep this structure as long as they paid some legal fees with no penalty. Again, the Jones had asked, excuse me, the Stiffs had asked to hear about that, but they were kept out of the loop. So we then looked into the zoning issue on the Jones property, which, we hadn't really wanted to figure out. But nonetheless, it turns out that the planning board had to approve this building, something neither the town manager nor the Jones acknowledged when they made their private agreement. Again, how'd that happen? So instead of going to the Board of Selectmen per their signed agreement with the town manager, Jones were told to go to the planning board. And that's just what they did. So they applied for an after the fact permit. Now, this is an important point that I have not really seen in my experience across the state of Maine. The planning board's review of the application was heavily influenced by the Belgrade Code Enforcement Officer, who had issued the permit wrongfully. I understand it's human nature to want to defend yourself, but it's not human nature to make mistakes and then try to say they didn't exist. The code officer never explained how this situation happened, how he allowed them to keep the building once he saw it built. He never explained why he didn't send them to the planning board. So, and he regularly provided testimony to the planning board on behalf of the Jones, as if he was their agent. Now, this harks back to the point I started out with. The planning board and the town of Belgrade were acting in lockstep instead of the planning board considering whether what the town was doing was incorrect. That's a problem. And it's led to a bad situation. The planning board allowed the code officer to act as if he was on the planning board. He spoke freely whenever he wanted to. When I was making presentations, he repeatedly interrupted me, argued with me, and the planning board chairman did nothing to stop him. Now, I think the planning board members were acting in good faith. I really do. They seem to be straight shooters, but they apparently work very closely with the code officer regularly, and they were just never disagreed with a thing he said. And the planning board showed its own bias by refusing to make the Jones file what the Belgrade Shoreland zoning ordinance requires it to file. I raised these issues beginning at the November 2019 meeting. I sent the planning board a memo describing a dozen or so application requirements that were missing. I sent that same memo. The list got slightly shorter for the next 3 meetings. The planning board never required the Jones to file important documents. I don't know why, but they didn't. In fact, one of the documents was the Jones supposed to file floodplain information, and they just didn't do it. So the planning board, on their own time, outside of the public process, in violation of the Maine Freedom of Information Act, dug up the necessary floodplain information that the Jones were supposed to submit. Now, I sat on a planning board for 12 years, and I never once even considered doing what the applicant was supposed to do. So that was surprising. And I guess what I really don't understand is why the planning board would treat the Jones with such deference when the Jones had applied to build a garage and wound up building a 3-bedroom, 2-story residence. It's like it didn't matter. They trusted everything the Jones said or their attorney did or said. But yet their actions speak much louder than their words. So as you consider this appeal, I really hope you consider the situation as if the residence was not there, that you were sitting in a planning board chair when the ground was still unbroken and being asked to build a 2-story, 3-bedroom residence. I think the biggest mistake that the planning board made, and they spent no more than 2 or 3 minutes talking about it, was deciding that this large structure was an accessory structure. Imagine what would have happened if you were sitting on the planning board with unbroken ground and someone came to you who had a 3-bedroom, 2-bathroom residence. And they said, you know, we want to build another 3-bedroom, 2-story residence with 2 bathrooms, almost as big, and we want to call it an accessory structure. I would hope the planning board would have quickly told them to leave. I think most of us think of accessory structures as garage buildings like they applied for, sheds, even bunkhouses, and buildings that are much smaller than the principal one. So when you look at the definition of accessory structure, I'm going to play English teacher for a minute. In your ordinance, it's a structure which is incidental and subordinate to the main residence. So those are funny words that are, you know, I looked them up, and Merriam-Webster describes incidental as, quote, being likely to ensue as a chance or minor consequence. There's nothing minor about this house. Subordinate is placed in or occupying a lower class, rank, or position, or submissive or controlled by authority. Well, the Jones primary residence has 1,900, almost 2,000 square feet, and the Jones new residence has over 1,800 square feet, about the same size. Both have 3 bedrooms, both have 2 bathrooms, both have large common living areas, both have a kitchen area, both have a covered outdoor patio with a deck. And both buildings can easily independently house residents during the summer. And the fact that the planning board said, no, you can't have kitchen appliances or prepare meals in this structure was a nice thing. However, this is a summer residence with a set of kitchen cabinets, a kitchen sink, and a kitchen island. There's large covered patio right off the kitchen where coolers, grills, food preparation tables could be built. They can eat there. They can store food there. They can wash dishes there. To suggest that it's not a residence because there's no kitchen appliances is a little bit silly for a summer place in Maine. When the planning board discussed this, it focused exclusively on the square footage stated in the Jones applications and took it as the truth. When in fact, if you measure the plans they submitted with the application, the numbers in their application were totally off. I'm not going to go through the details now, but that's all the planning board did. They took some numbers off an application, which they didn't check. And that's the only thing they discussed, when it's far more complicated. So another interesting point is I want to make, because I think it's important, was the day after the planning board decided this was an accessory structure, the Jones signed an affidavit in Superior Court in a related lawsuit stating that this building is an addition to our single-family dwelling. And our single-family dwelling consists of 2 buildings. So they just made sworn statements that this is just part of their house. And they told the court everything except that it's an accessory structure. They're just saying, hey, this is just another house. So I don't know how we can get away with that. So it is our position that this structure that is virtually the same as their existing structure is not an accessory use under the Belgrade Shoreland Zoning Ordinance. And therefore, you should deny the permit because it's an unpermitted use. That's the big argument that the stiffs believe is a major error. Now, I know I've been talking for a long time and I hopefully won't talk very much longer, but I think it's important that everyone hear the full story. There are 3 items that the Belgrade Shoreline Zoning Ordinance required the Jones to submit that they never submitted. Never. 1, a certified soils report from a state certified professional. I told them about it in November. They didn't do it. Planning board said, no, look at their application for a septic system, which has some soil profiles. But yet the ordinance, which the planning board apparently didn't read, required the soils report to contain an analysis of the characteristics of the soil and surrounding land and water areas, maximum groundwater elevation, presence of ledge, and other pertinent data which the evaluator deems appropriate. None of this information was provided, ever. And I want to point out that one of the exhibits I attached was a report put out by your Regional Lakes Association highlighting the really heavily challenged soils in this part of the town to support septic systems. And yet the town is apparently going to let these people add a second residence to a narrow non-conforming lot. I talked earlier about the floodplain elevation information. The Jones just never did anything. So the planning board did it for them. We never saw the information. Maine Freedom of Information Act, I'm sure you're familiar with it, requires that everything be done publicly, yet this information was entirely done privately. I don't know why the planning board would do that. And finally, the ordinance required a soil and erosion control plan for the construction. We harped on it for months and months and months. The planning board never said they needed it. Jones never submitted it. Finally, at the last planning board meeting, when they approved the project, at least 1 or 2 of the members read, you know, we probably ought to have this report. So they approved the project and allowed the Jones to file the report later. Again, why? These are the people that built a house twice as big as the permit allowed. So I am going to stop talking after this quick summary. You know the story. I'm not going to repeat it. But the points are, one, I think you should declare that this residence is not an accessory structure as defined by your ordinance. I think you ought to declare that their application did not comply with the requirements of the Belgrade Shoreland zoning ordinance. I think you ought to decide that they made findings of fact which weren't supported by the records and error in law and how they interpreted the facts. And ultimately, we hope you uphold the appeal and send this case back to the planning board with instructions that the application should be denied. So thank you for your patience. The Stiffs and I are happy to answer any questions. Otherwise, I'll shut my microphone off and listen. Thank you.
Jim?
Mr. Chair, just as a quick matter, I don't mean to interrupt the public hearing. Before we hear from more of the appellants and the public who might support it, I see that Elizabeth Fontaine joined us, and I believe she's an alternate.
Yes.
Then if you want, it would be appropriate if we have someone absent and you wanted to promote her to become a member for these appeals, you could do that. And she came in at this meeting about 6:17 or 6:18.
Well, actually, Richard Bourne has showed up now.
Oh, okay.
And he's an active member, so a voting member.
Didn't see him on my screen. Oh, there we go. Okay, got it. Thank you. I'm sorry. Okay. Sorry. So we do have a full complement of board members at this point.
Yes, thank you.
Okay.
At this time, does any of the board members have any questions of Mr. Neagle? Mr. Bradshaw?
Just a couple of questions, if I may. Mr. Neagle, what was it that caused Gary to go out and inspect in 2018? Was there some action that was taken or contact that was made? Did I lose him?
Chris, you have to unmute.
Sorry,
There we go.
I apologize again. The code officer is required to do inspections at various points during construction of a residence. For example, when the foundation is built and open, he needs to inspect it. When the building is framed, he needs to inspect the wiring and plumbing that's installed. It's obvious, I guess I don't know as a fact that he was there, but it's obvious the town or someone was there to inspect, or if they weren't there to inspect, that may be worse than that's what they're supposed to do.
No, I was just trying to get a handle on whether this was part of that normal inspection, or if you had information that it was something other than part of the normal routine inspection that the code enforcement officer would do at different times.
I have nothing other than a strong assumption that the town was out there inspecting it as it was being built and before sheetrock was being put up.
Okay, so part of the normal inspection. Okay, you have the dates. You referred to meetings when a settlement was made in a private agreement, absent the FOIA requirements. Do you have the dates of those meetings?
Well, there were two separate settlement discussions that I'd mentioned. The first one was between the Stiffs and the Jones, and to respect the confidentiality of those agreements. No, but there was a separate negotiation between the town and the town and the Jones.
That's the one that I was referring to.
That was in the fall of 2019, right after the Stiffs reported back to the town that their negotiations with the Jones had failed and they wanted the town to do something. And what the town did was enter into private negotiations, allowing them to keep it there. At least that's what the town manager did. I don't mean to say the board did it or anyone else.
Oh, I just want to make sure that I understand that point. So in the fall of 2019, is it your statement that there was a private meeting that was held between the Joneses and some representatives of the town, and as a result of that meeting, there was a private arrangement that was made that would allow this to go forward with some financial consideration?
Yes, it's actually attached to one of my planning board memos.
I hope
But-
you'll understand. I've got piles of paper here. So
Okay, I can understand that. So the timetable was spring of 2018, we find the building that's surprised.
Yep.
Approximately a year went by where both parties surveyed their land because there were building setback issues and then tried to work out a settlement. When that all fell through, the Stiffs asked the town to have the building removed. And instead, the town manager and the Jones, I don't know if they had a meeting or communicated by phone or email, but I did, after a month or so after I asked the town manager to keep us informed, he sent me, or someone sent me, maybe it was the town attorney, a copy of a signed agreement between the town manager and the Jones. And I, on behalf of the Stiffs, had to inform both parties that the town manager does not have any authority to settle land use violations and that only your Board of Selectmen can do that. And it was only after all that took place that the Jones were told they finally had to go to the planning board.
thank you. I don't have any other questions at this point. Thank you.
Norma, Mrs. Blazer? You're muted.
Okay, I just have one question. I can't find that discussion of the whether or not this building is a residence versus an accessory structure in the minutes. So what meeting did they have that discussion? Do you recall?
Yes, it was at the June meeting. It won't be in the minutes. It's not in the minutes.
Okay,
We all know that taking minutes is an inexact science. There is, I believe, Mr. Wilson did a good job of getting a recording of the Zoom meeting that's part of your record if you wanted to hear that discussion. But it's, you're not, the minutes I think were, and I understand, I think whoever took the minutes probably did a more summary job because anyone who wants to see what really happened can just go look at the meeting. One of the benefits of Zoom meetings.
that's it. Thank you very much.
Mr. Bourne, do you have any questions? I think Dick is muted as well, so. I think he's having some issues. Okay, Jim, I'm all set. Dave, Bonar, do you have any questions?
No, I can't think of anything at the present time. Chris, the agreement that you referred to was the administrative consent agreement of the 25th of October between the town and the parties?
2019?
Yes,
Yes, that's it.
thank you.
Jim?
Bearing in mind that at this point it's the appellant's case to put on, if there are any other speakers on behalf of the appellant or any members of the public who want to speak on behalf of the appellant, this would be the appropriate time, and then we turn that over to the Joneses.
Okay, Mr. Bean, David Bean.
Yes. Again, thank you all for your time and effort here. I'm going to be very brief because I think everything's been covered. I am a camp owner down in Sandy Cove, and I have followed the shoreline zoning rules. Very important to me to preserve the lake. And as far as I think what the Joneses have done, have broken those rules based on the stiff's information that you have in front of you. And I don't know if you're going to make a decision tonight or review this a little bit more thoroughly to come up with your decision. But again, I feel the Joneses have violated the rules based on everything I've read, heard, seen, and I have been at all the planning board meetings since day one. So without any other information, I'll stop there and thank you for giving me a few seconds of your time.
You're very welcome. Thank you. I don't see anyone else that would like to speak, so I'll turn it over to Mr. Cunningham.
I think you have some other folks who would like to speak.
Oh, okay.
Mr. Hano, Mr. Forsberg was raising his hand.
Yes, go ahead, sir.
Yes, can everybody hear me now?
Yes.
All right. My name's Eric Forsberg. This is my wife Yvonne, and we have a camp up on 17 South Sandy Cove Road up at the other end. And I can tell you that my wife and I are in complete agreement with what David Bean just said. In fact, we applied for a bunkhouse through Gary Fuller back this fall. And I can tell you that never in 1,000 years would I try to build beyond exactly what he required. I had to make very specific detailed plans on a graph paper with all kinds of measurements. It's a 12 by 16 structure. He was very adamant about no kitchen. So we're not going to have any of that. There's going to be a toilet with an indoor shower. There's going to be a countertop with a sink only. Probably have a coffee maker on that countertop. But the point is, my wife and I are conservationists. I know there are reasons for these rules. And I was very specific when I went through the process with the town of Belgrade, that it was our intention to follow exactly what the ordinances were. So that's really all I have to say, but thank you very much.
Thank you, sir, for your input. Anyone else? Okay, Mr. Cunningham, floor is yours.
Thank you. I guess I'd like to start out by pointing out that although the situation has a lot of complications to it, your ordinances and the law segregate a lot of these issues into compartments so that they're handled separately by different groups. And Jim Katsiaficas spoke near the beginning of the session as to what is the role of the Board of Appeals. And I'd like to try to keep my comments limited to what's relevant here, but I suppose I need to start by saying that certain things that probably are of great interest are not actually relevant to this evening's hearing. In particular, the planning board was charged with reviewing an application that had been presented to them for a building that had already been built.
Now, that's not the way it's supposed to happen, but it does happen from time to time. And the planning board granted that permit, and appeals have been filed from the decision of the planning board. That's what's in front of the Board of Appeals. What happened before that application was presented to the planning board is not relevant tonight. For instance, there's been talk about a potential agreement between the town and the Joneses perhaps dealing with potential zoning violations. So far as I know, that's a process that may still be occurring and that no final decision has been made. I think in part because it was felt the process of going through the planning board and now the appeal should be done first. That may all be of great interest and certainly of great public interest, but it's not on the table before us tonight. It also wasn't in front of the planning board. Their job was to look at the plan presented to them, which certainly was different from the plan that had been presented earlier. And they had to review that plan, follow their procedures, and make up their minds whether they thought that plan could or could not be approved. And so I just want to point out, that's what's really relevant. The board made findings as it was required to. You understand that it, in fact, had failed to make those findings at first and had to be reminded by you, the Board of Appeals, to make the findings. So they held a further meeting and made their findings. A major finding, it appears, as they begin the list of their conclusions of law and findings, it's at the bottom of page 1 of the board's findings. It's not a numbered finding, but their first finding is that the Joneses project is a permitted accessory structure. Now, Mr. Neagle cited to you the ordinance definition of what is an accessory structure. I'd like to point out that there is nothing in the ordinance, a definition of an accessory structure, that talks about any size limits. I think we can all recognize that somebody might build quite a large accessory structure, like a barn. Could easily be much larger than a house. In this case, as Mr. Neagle did point out, this accessory structure is smaller than the main house, though in fact, it's large. I'm not going to deny that. It's a large structure, but it's still an accessory structure as found by the planning board. The chief reason, and they say this in their findings, is that they found that it is not a dwelling and they imposed condition 1 of their conditions, that's on page 4, to clarify that this is not a second residence. Now, Mr. Neagle, I understand why, has referred to it more or less exclusively as a residential dwelling. I don't care what Webster says. I do care what your ordinance says. And your ordinance says in the definition of a residential dwelling, which is on page 86 of the ordinance, is that it contains cooking, sleeping, and toilet facilities. There's no restriction against cabinets, counters, or sinks, or the kinds of cabinets you might have in your structure. But you can't have cooking facility, you can't have all 3 of those things, cooking, sleeping, and toilet facilities. So the planning board imposed a condition on the Joneses that this structure cannot be used for the installation of kitchen appliances or the preparation of meals. Those are prohibited. Now, is it possible that the Joneses or somebody else owning this structure could violate that restriction? Yeah, I suppose it is. But that's true of any permit issued by the planning board to anybody in town or issued by the code enforcement officer. Anybody can violate the rules, and somebody could in fact put kitchen facilities into their garage. That doesn't mean that permits can't be granted with restrictions and conditions. It just means that the enforcement of those is subject to a different process. That's what the Code Enforcement Office does. That isn't part of the planning board's duties. They're not required to say, by the way, you can't have any room that's of this size or that gets the morning sun, because that would be a convenient place to eat your breakfast. No, they can put in a restriction that says you can't install kitchen appliances here and you can't prepare meals here. I don't know that they could have made that much plainer. And as a result of that, by the definition of the ordinance, this is not a residential structure. It's not a residential dwelling. It is, in fact, as found by the planning board, and I think you should uphold their decision, it is an accessory structure. It is not a separate residence. It can't be used as a separate residence. Couldn't be sold to anybody as a separate residence because it can't be. It has a prohibition against doing one of the things that would make it a residence. I would also point out that the picture Mr. Neagle has drawn your attention to of what the kitchen looked like in 2018, it no longer looks like that because, of course, the Joneses have been removing what shouldn't have been there in the first place. Are you asking me to admit that they'd made mistakes when they were undergoing their construction? Sure, I'll admit that. And when it was brought to their attention, they've attempted to deal with that. Now, again, though, that's a separate issue. That's not what was in front of the planning board, and it's not what was in front of us tonight. The ordinance requires a soils report. Finding 8U at the bottom of page 3 of the planning board's findings addresses this. They found that this requirement had been met based on the report that was part of the septic system application, which was made by a state certified soil site evaluator. The ordinance does not require that it has to be a particular officer. The ordinance says that the report may be made by persons who have training and experience in the recognition and evaluation of soil properties, which the planning board found that this site evaluator for the septic system met that qualification. He is state licensed. The board found that report to be satisfactory to them. And I imagine that you may consult with Mr. Katsiaficas about this, but the goal or the review of the Board of Appeals is not to put itself in the place of the planning board and decide how you would have acted had you been the planning board, but instead to decide whether or not the board was following the ordinance, the planning board was following the ordinance, and whether their decisions were supported by evidence. That's obviously something you'll want to consider and debate. But if I urge you to recognize that the place of the planning board is to make these decisions, they do it regularly, and you should consider that in your deliberations. As for the floodplain, there is nothing in the ordinance that necessarily requires that the applicant has to present the evidence that Mr. Neagle was saying. It is true, absolutely true, that the applicants have the burden of proof. Had there been no evidence on this point submitted to the planning board should have found against the application, and that would have been the applicant, the Joneses' fault, because they bear the burden of proof. However, not long after that meeting in November of 2019, board members went out and took a look at the site on their own. And as they stated later, they realized that given the slope of the site, it occurred to them that that lower floor of the new structure had to comply with the standard. And they asked the code enforcement officer if he could offer testimony on that point. And he said, yes, by looking at the town maps, it was his testimony that the project site was not in the special flood hazard zone that was the ordinance is talking about. And the board further verified that testimony by reviewing the applicable FEMA maps online. They chose to do that. They have the right to do that if that's what they want to do. And they say in their findings that that's what they did. That's finding 7 on page 2 of their findings. That's what they chose to do. There's nothing wrong with that. The soil erosion sedimentation control plan. The board did not require that until, as Mr. Neagle says, more or less the final moment they realized that it ought to have been submitted. They did not approve the project and say that the Joneses could submit that report later. That's not a fair way of putting it. They made a condition. The project was approved only upon this condition, amongst others. But the project was approved only provided that such a report be prepared and submitted as set forth in the ordinance, which would then need to be reviewed and approved by the planning board. Had they not, the report was submitted to them. Had they not approved it, the application would not have been valid. That was a condition of approving the application. In point of fact, the planning board did approve that report at their November 19th meeting. They found that it met the requirements of the ordinance. They discussed it at considerable length. I don't know if you are allowed to check that portion of their record. It is part of their activities in approving the application, but it is something that they didn't get around to doing until after the appeal had been filed, though it was still a condition of the application. So I'm sure Jim will inform you on that as to whether you can, if you're allowed to take a look at their meeting reports on that. Although Mr. Neagle didn't talk about it, in his written report, memorandum, there is some comment about the board, planning board, in its finding 8F, that they found a slight enlargement of the parking area. There was more discussion of that at their meeting approving the soil erosion control report. But they found that the project met that standard in part premised on condition number 2, which covers, it covers management of the site in accordance with the DEP stormwater management practices. And the board found that that condition, as applied to not only the structure, but also to that expansion of the parking area, which none of us are entirely sure that there is an expansion of the parking area there. The planning board found that met the requirement. So my argument to you, I guess, is that within the scope of an appellate review, I believe that the planning board has explained its findings, that its findings are supported by evidence in the record, and that they have not misinterpreted the ordinance. And therefore, I request that you uphold the planning board. Thank you. And I'm happy to answer any questions you may have of me.
Thank you, sir. Jim?
Jim, as you originally had allowed questions of the appellants, then it would be appropriate perhaps to have questions from Mr. Cunningham and then to allow the parties to have their rebuttal if no one else wants to speak.
Does any of the board members have a question of Mr. Cunningham? Okay. I guess we don't, Jim.
All right. Was there anyone else who wanted to speak on against the appeal? Then it would be time to go to those who would serve their rebuttal. It would be time for Mr. Neagle to give his rebuttal remarks.
Thank you, Jim and board. I will be brief. John is correct that the negotiations between the town and the Jones prior to going to the planning board aren't directly relevant to this appeal. However, I think those facts are relevant to the fact that for reasons that are unexplained, the town of Belgrade, through its town manager and its planning board, showed a strong bias in favor of the Jones. I don't think there's any dispute about that. If you watch the meetings, you will understand what I'm talking about. John's discussion about the detailed requirements for a residential dwelling unit were interesting, but not relevant to this appeal. The stiffs are not arguing that the new Jones structure is a residential dwelling unit as defined by your ordinance. They never have. And the Joneses are not telling you that they're building a residential dwelling unit. So that whole concept is not relevant to this appeal. And Mr. Cunningham would have you believe that everything that is not a residential dwelling unit must be an accessory use, because we should be allowed to build anything we want to, is the only thing that supports that logic. They do not have to prove that the building is not a residential dwelling unit. They have to prove that it is an accessory structure. And all I can tell you is that one look at that picture should convince you it's not an accessory structure. Now, final points. Mr. Cunningham said it was not the Jones obligation to provide information. I submit that he was incorrect. In fact, if you look at 16D in the shoreland zoning ordinance, it says very specifically, the Jones have the burden of proof to show that their project meets all shoreland zoning ordinance review standards. The Jones have the burden of proof. The Jones did not meet the burden of proof when the planning board did the research for them. The ordinance is clear, and again, a question I do not understand. Mr. Cunningham's a very good lawyer. The ordinance is very clear about what is required to be shown to the planning board before it can approve a project. These words are in black and white and people have ignored them. The Jones have failed to produce 3 key items. If the planning board made a finding that the soils report met the requirement, soils profile in the septic system application met the requirements for a soils report, he did not describe where in the soils report it described ledge, general conditions, etc. Again, specifically required by your ordinance. So those are my points in rebuttal. Again, thank you for listening. I've answered any questions.
Thank you, sir. Does anyone have any questions of Chris? Okay, Jim, do you have any questions?
Jim, you're muted.
I have one.
Okay, Mrs. Blazer?
Yeah, I would like to know, can we, while everybody's here, agree on which site plan is the one that came in with the application for the permit, the Jones permit.
May I respond?
Yes, Mr. Cunningham.
Thank you. The site plan is a plan prepared by K&K Surveying. Shoot, I apologize. I've got the larger version. It has red markings on it. I'm not sure if that looks good. Let me find the larger version because that's where the date is. But it was, there we go, excuse me.
John, if I could help out.
Dated February 2020 from K&K Land Surveyors, labeled site plan.
Where's the date on that?
In the lower right, there's in the title block, there's a section that says date, February 2020.
It's the same date? I mean, the portion of it that's enlarged, the other page.
Yes, the enlargement, if you look at the two together, you'll see that the enlargement is nothing more than an enlarged portion of that site plan.
Okay. Thank you.
You're welcome.
And I'm sorry, one more. May I, Mike?
Yes, go ahead, Norma.
The subsurface wastewater disposal system application that came in with the permit application, is that the signed version? I don't know. It's got several dates on it. The last one is January 21st, 2020.
May I?
Yes, go ahead.
No, that's not the, well, excuse me. With the application, there was, with the application for the planning board for approval of the structure, there was an application for the subsurface wastewater disposal system. So that was included with the application. But before the planning board can consider the application on the structure, the plumbing inspector had to approve or not the wastewater application, and he did. So you should have amongst your records, the document looks exactly the same, but on the first page in the upper right, in darker ink, it's been signed by Gary Fuller, the local plumbing inspector, and it's dated just above his signature, February 25th, 2020. And that is the signed version. So far as I know, I don't think there's any difference between the two other than Gary's signature, but you'd want to be using the one that he signed.
And that came in February of 2020 or so, right?
Yes, in fact, it went in with the application in January, earlier, and he signed it on February 25th.
Thank you.
Thank you.
Norma, you had put together a list of the documents, and the first one is the revised permit application. That includes the septic application that John Cunningham just referred to. And then the second, the signed septic, is the actual septic permit that issued on February 25. That's in the list that you prepared of the documents. Just to refer you back.
Okay, so that one's the unsigned one.
The unsigned one went in with the application, and then the signed one is the second document, and that's the February one.
Thanks.
Anyone else? Jim?
I think the one thing we might want to do, there were some documents that were received by the town. There were letters and emails, and we might want to make sure those are part of the record of the Board of Appeals proceeding, just for the, make sure we have those in. There were 3 letters submitted on December 4th. One by Lynn Moore and Robert Moore, December 4th, and the subject was the appeal by John T. Sutton. Actually, we'll put that in the other matter. There was one by the Moores, December 4th, with regard to the Jeffrey and Carolyn Stiff appeal. And then there was one dated December 4th from the Moores regarding the Sandy Cove Road. It was concerns from the Sandy Cove Road Association. We also had emails that had been sent in by Paul Bean on December 14th and by Don Appleton on December 15th, by Wayne Kugel today. A response from Jack Sutton on December 9, and an email from Rudy Heinz or Heinze. So those all had been sent to the town. They've all been circulated to the board. They've been circulated to council, so they should be considered part of the record of this proceeding. It's not part of the planning board record, but it's record of this proceeding, and it's basically argument, just as you've heard from the parties who are here tonight in this matter. So with that, be in order for the board to close the public hearing if there are no further comments. And then you could either begin deliberation or you could hold the next public hearing on the Sutton appeal and begin your deliberations together, whatever makes more sense for the board.
I think it'd be my preference to take a 5-minute break if everybody's in favor of that, and then come back. We'll close out the hearing on the stiffs at this time, and then come back and listen to the Sutton hearing.
Is there a motion to close the public hearing?
So moved.
Okay, let's have a roll call vote because we're on Zoom.
Can I have a second?
Second.
Okay, thank you.
Sorry, was that Jay?
Yes.
Okay, roll call vote on the motion made. Norma Blazer,
Yes.
okay. David Bonar,
Yes.
Dave Bradshaw,
Yes.
Dick Bourne,
Yes.
and Michael Hano, yes. Motion is carried 5-0. So we'll take a 5-minute break. It's like 7:25. We'll come back at 7:30 and begin the second hearing. Members present, Mr. Neagle is back, Mr. Cunningham, Mr. Sutton. Missing Liz Fontaine. But I think this time we'll reconvene. It's 7:34 p.m. Reconvening of the Belgrade Board of Appeals meeting December 16th, 2020. And to hear a second appeal, appellate appeal. Consideration of appeal dated September 7th, 2020, filed by John T. Sutton and related to a recent Belgrade building permit for a second major building and plumbing changes on Jones Lot, Sandy Cove on Long Pond. Jim?
Yes.
Jay has one question before we begin.
Thanks. Well, just as you did before we heard the stiff's presentation, I'm wondering if you could help us. I'm struggling with the boundaries of what do we do in this case. In the last case, it was to act on the findings of the planning board. But this one is a little bit less clear to me. Can you help just perhaps restate where our responsibility or roles lie and where our limits are with regard to Mr. Sutton's?
Sure.
appeal?
They're actually identical in terms of your roles and boundaries. These really are identical. In each
Except
instance, I'm sorry, go ahead.
No, except that in the previous case, we had the findings from the planning board.
You have those before you as well. In this case, really, it's an appeal from the decision, and the decision of the planning board is explained by the findings of fact and conclusions of law. They're different arguments based on the same decision and the same findings.
Okay, thank you. The findings of fact only reference the Jones. Oh, I see. Okay, scratch that, forget it.
That's all right. No, I understand. But it may be helpful just to step back a little bit and think about what we're doing here, because there are a lot of facts, there are a lot of arguments, there are a lot of things that were said before the planning board, a lot of things. The real issue here tonight is that you're holding an appellate hearing, and you can reverse the planning board's decision only upon finding that that decision was contrary to specific provisions of the ordinance or contrary to the facts presented to the planning board. You're looking at the planning board's record. You're standing in the shoes of the planning board, reviewing the record that was presented to them. You are not deciding the case anew. You're looking at it and you're saying, did they do the right thing? Did they apply the ordinance correctly? Is there factual support for what they did? You're just reviewing what they did. You are not hearing this anew. You're not going through each criterion. And so there are arguments that were raised by Mr. Neagle. He raised 5 prime arguments in his memo. And there are 2 arguments raised by Mr. Sutton that are different. And so so that's why there are 2 different appeals, different reasons, but from the same decision. It's a little unusual, but the relationship is it's the same decision being appealed from. You are not to look at these facts and say, would I have come out the same way? It's, did the planning board correctly interpret and apply the ordinance? To the facts that the planning board found support, are they supported by what's in the record? Does that help with the board?
It helps me. I think we'll have
Yes,
more questions about that when we get to the workshop section, but thank you.
Okay. Jim, do you have anything else? We just continue with, listen to Mr. Sutton?
I think it would be the appropriate time for the appellant, Mr. Sutton, to make his statement.
Mr. Chairman, thank you very much for you and all of the members of the appeals board for taking the time to hear me this evening. I appreciate it. I appreciate the others who have come to listen in on behalf of this appeal. By way of introduction, most people call me Jack, by the way. By way of introduction, I'm no lawyer. I'm not qualified to argue fine points of the law here. I do have a fairly decent, I think, sense of what's right and what's wrong. So I'll be coming from that point of view more than I will be from points of the law. As far as standing is concerned, the Shoreland Zoning Ordinance Section 1 under purposes includes a statement to anticipate and respond to impacts of development in shoreland areas. On page 75, under definitions, it says an aggrieved party is a person whose land abuts land for which a permit or variance has been granted. Our land is on the north side of the Jones property. It's a point. The boundary between our land and the Jones land contains the only access that we have to our land other than by water. It's surrounded by water on the other sides, and it's greatly restricted by that water and the setbacks from that water on where a building could be built. Make no mistake, it's not our intention to develop and put a building on the land. Our daughter Nancy Bayless and son Richard Sutton are on this call tonight and listening in. They're the heirs apparent. I'm 86 years old, and it won't be long before somebody else is arguing for keeping this land. We all want to keep it in its natural state and enjoy it in its natural state and not build upon it. What somebody in the future may wish to do with it is not my concern at the moment, except to leave it in a way that is basically unspoiled and accessible as it is now, we hope. We do have a right of way across the Jones land. It's not been defined dimensionally in the deed. The deed goes back to, I think, 1969. That's how we get there and back. We don't get there by water. And it's that right of way I'm trying to defend at this point. There are two issues involved in our appeal. One is the septic system. The proposed septic system, it hasn't been built. It's been staked out on the ground. I don't know the exact setback from our property line, but it's very close to the property line. The septic system, as I understand it, will be designed to be connected between the original building on the property and the second building on the property. Each one has 3 bedrooms, assuming 2 people per bedroom. That's doubling the capacity, the bedroom capacity, the sleeping capacity, and presumably the water use capacity of that property on a non-conforming lot. And it will all go through the discharge system that's laid out. If you turn a few pages from the first page on the appeal, there's a sketch based on well, it's actually a plan that's based on the Jones property. It shows the where the right-of-way comes from the south on the Sandy Cove Road, and it meets the boundary of Jones, the south boundary of Jones. There's in the original typed logo, as it approaches, it shows 30 feet wide right-of-way. That's the Sandy Cove Road. Since we have a right-of-way over the Sandy Cove Road, I think it's reasonable to assume that the offsets would be the same from the center line as it is from the Sandy Cove Road. And I've sketched in where I think our right-of-way should be. It is very, very strange to me that the planning board, with all its interests in dimensions and how big a porch is and how big a patio is and how high a building is and so forth, has steadfastly refused in several requests actually to require that the dimensions of that right-of-way be shown. Now, if you look down that right-of-way, down the center line on the left-hand side, look to the north, I've put a note in Jones proposed septic discharge. And there's a rectangle there divided in 3 or 4 little sections. And it just touches what appears to be a boundary line. But if you take the right-of-way, the right-of-way would go right through that septic system. Now, I don't know why that septic system was put there. I can guess, it's my guess, that it was put there to get 100 foot, or close to as 100 foot was possible on that property, separation between the well and the discharge of the septic system. And that's required, I understand, by plumbing code. However, if we wanted to, or somebody else in the future wanted to put a well on our property, a logical place would be not too far from the northern property boundary. The offset from that proposed discharge would foul either by fact of the septic system itself or by the law of the 100-foot setback, would foul a substantial portion of our property from ever putting a well in. And it wouldn't be something that's reversible. It would be literally fouled permanently. We object to that. We object to the septic system being put so close to the property line that it fouls a portion of our property. I don't know where else it would go, frankly, but that's the result of what is happening on the Jones property. And we object to that. we object to it for a couple of reasons. Number one, the fouling of the well, but number two, there's every chance that either to the right or to the left of that, but on our property, septic effluent will flow across our property underground and foul the lake water. And if it does, it will be from our property. Who's responsible? Who has the liability? Who has the cleanup? Who has the responsibility for it? We don't have a septic system, but it's placed so that some of that drainage is bound to be on our property. I asked about that at a planning board meeting. The chair of the planning board turned to the code enforcement officer and he asked about that, and his response was, first come, first serve. We bought our property in 1963. We have the deed to the right-of-way in 1969. When you talk about first come, first serve, I don't know whether that applies to us or just to the code enforcement officer's interpretation. Those are my concerns about the placement of the proposed septic disposal. The right-of-way, we feel that because it approaches our property from the south, the Sandy Cove Road right-of-way is 30 feet wide. We feel that where we have a deeded right-of-way, which is not dimensioned in the deed, where we have a deeded right-of-way to that road across the Jones property to our property, that right-of-way width should be maintained. We have no argument with the center line placement as was originally on that map or a map like that. But we want that width defined so that we know from a maintenance standpoint, from a travel standpoint, from an additional parking standpoint that's going to be required for the Jones additional building, and for the placement of utilities, which is in our deed. We need more than just a travel right-of-way for an 8-foot wide vehicle. And that's why we're asking that the planning board, which has strangely refused to put widths on that right-of-way, we're asking that the right-of-way be defined as it is for the Sandy Cove Road, which it is a continuation of. And basically that's my story.
Thank you, Jack. Tim, do you have any comments?
Any questions from the board for Mr. Sutton?
I have a question.
Mr. Bourne?
Jack, was a copy of your deed supplied to the planning board for inclusion in their record?
I didn't supply a copy of the deed. I supplied a reference number of the deed.
Okay, thank you.
Do any other board members have a question of Mr. Sutton? Okay. Jim, do you have any questions?
None. Are there any members of the public who would speak on behalf of the appeal or in favor of the appeal?
I don't believe there are.
Then perhaps it would be Mr. Cunningham's turn to respond.
Chairman?
Yes, go ahead, Jim. John, rather.
Thank you. I'd like to say, having met Mr. Sutton at several planning board meetings, He has always approached discussions in a very gentlemanly manner, and I appreciate that, Mr. Sutton. But there are some things where I now have to argue that why I think you're wrong from a legal standpoint. Actually, the easier issue is the width of the right-of-way. When rights-of-way are created, when easements are created, oftentimes the width of it is stated, but sometimes it isn't. And that's just how it goes sometimes. Some are given a width, some aren't. If an easement, if a right-of-way is created without a given width, there are some principles of law where that might get resolved in a court case. Other things might happen. But from my standpoint for tonight's discussion, that's not something the planning board could do anything about. The evidence in front of the planning board appears on the site plan prepared by K&K surveyor and signed by prepared by a licensed land surveyor. He has a note pointing to the center line of the right-of-way as it crosses onto the Sutton property. And he says, here's the center line of the right-of-way, no width stated. And then he gives a reference to the book and page of Mr. Sutton's deed. If there is no width stated in the grant of that section of the right-of-way, then it doesn't have a set width. As I said, it might be something that will get determined later in some other forum, but it's not something the planning board could set. The road was not created all at once with a set width. The various sections of it were created as each piece along the way was granted, and it was said you were subject to a right-of-way of a certain width. And there simply is no such number available for Mr. Sutton's right-of-way. There was nothing for us to get the surveyor to mark on the plan as the set width of the right-of-way, and there was nothing the planning board could do about that. We showed, of course, the center line of the traveled way, and that was all we could do. The other issue on the septic system, first, one of the reasons that the proposed septic system on the Joneses property is where it is because the Joneses were required to make sure that it was sited more than at least 100 feet away from a well or another septic system, I think it was a well, on neighboring property. It may not be fair, but the rule about keeping wells and septic systems 100 feet away from each other is set forth in law and regulation. And it is a matter generally of first come, first serve. I know that may sound callous, but because of neighbors having put in a well already nearby, which they had every right to do, the Joneses are therefore restricted on where they can locate a septic system. The location of this septic system may interfere with where facilities may get located on the Sutton property. That's just the way the rules work. And again, it's nothing the planning board could have done anything about. Mr. Sutton raised the issue of fouling the lake water. That's certainly a concern of everybody, but the licensed plumbing inspector is required to review the septic plan before approving it and making sure that it's a well-designed plan that we hope will not foul the lake water under any circumstances. I suppose that any system can break, and then it would be up to the people who own the system. They'd be responsible for fixing it and trying to deal with any fouling that it might cause. But the system is not designed to break, of course. It's not designed to foul Mr. Sutton's property or to foul the lake. And again, that wasn't really an issue that the planning board could do anything about. That was an issue for the licensed plumbing inspector to decide when he was approving that plan. That happened in February of 2020. There was no appeal of his approval of that septic plan. There was some discussion by the planning board about, where are the edges and would there be issues? And they looked at the plan, they looked at the location and found that it was, in fact, well designed. Again, I'm sorry that some of these things may seem unfair to Mr. Sutton, but the fact is when locating a septic system or a well, there is an element of first come, first served. And when it comes to expressing the width of the right-of-way, there is no set legal width of that. Though again, if it were something that had to be determined by a court, there are rules the court might apply, but that's beyond the purview of anything the planning board could have done. I'd be happy to answer any questions you may have of me.
Thank you, John. Mr. Sutton?
May I respond to that?
Yes, you may.
With respect to the right-of-way, the width of the right-of-way is listed on the map. Not my notation, it's listed as 30 feet. That's the Sandy Cove Road. My understanding is that the Sandy Cove Road extends into or through the Jones property to our property. The deed that we have gives us the right-of-way over Sandy Cove roads from the Dunn Road to our property line. If the road width is 30 feet as it approaches Jones, it seems quite logical to me that it should stay 30 feet till it goes to our property line. That's my take on it. As far as the septic discharge is concerned, first come, first serve, we would be in good shape, I think, if we had a piece of property to our north on which we could slough off a septic system of our own. We don't. We have lake on every side but the Jones property. Those are my comments.
Thank you, Jack. Does any board member have any questions of Mr. Sutton or Mr. Cunningham at this time? Okay, James, do you have anything to say at this time?
I don't know if there are any members of the public or any council who haven't spoken on this matter, but it would be time for those folks to make their statement and then to close the public hearing if no one wishes to speak.
This is Richard Sutton. I just can say a couple of words in support of what my father, Jack Sutton's been talking about. I and my family have enjoyed and cared for that property at the end of Sandy Cove Road for my entire life. Just want to add that installing a septic system for a building that was constructed out of code on a piece of land inadequate to support it, a second building may somehow wiggle through for ultimate planning board approval, but anyone looking at the facts on the ground would have to agree that dumping your effluent onto your neighbor's land because there's no place to put it on your own and compromising your neighbor's sole legal right of access to that land because you choose to turn it into a leach field for the waste from your potentially what looks to be an Airbnb accessory unit. This violates precisely the conditions that the Planning and Appeals Board, it seems to me, were created to uphold. Thank you.
Thank you, Richard. I don't see anyone else. Does any of the board members have any questions? If not, we will close this hearing, the second hearing for the evening.
Is there a motion to close the public hearing?
I so move.
Second.
Dave Bonar seconded it. Okay, thank you.
Roll call vote.
Yep. Roll call vote. Norma Blazer,
I vote yes.
Dave Bonar,
Yes.
Richard Bourne,
Yes.
Jay Bradshaw,
Yes.
Michael Hano, yes. Motion carries 5-0 to close the second hearing. At this point, I would like to ask the board if they would like to continue with deliberations. Do I have any input on that? What is your take? Jim, what do you think?
It's up to the board as to how it wishes to proceed. You're in the deliberation phase right now. The public has spoken. Members of the public and counsel for the parties don't have a right to speak at this point, but you certainly may ask them questions if you do have questions, if you have things you need to follow up on. One way you might approach this is Mr. Sutton has raised 2 issues and the Stiffs have raised 5 issues. You could go through each appeal, those issues one by one and see if you reach some consensus. You don't necessarily have to make a decision tonight, but if you could reach some kind of consensus, then maybe I could put together a draft that you could look at, come back 2 weeks, a month, your next regular meeting, whatever, and then you could decide how you want to come out on those findings and on your decision. But that's up to you. I don't know how you operate best. I do know that once you close a public hearing under your Board of Appeals ordinance, you have to issue a decision within 30 days.
Correct. Mr. Neagle?
Oh, thank you. I just wanted to ask Jim about the 5 issues he claims you need to review. Looking back at my memo, I believe we made 4 arguments.
Chris, you have to speak up.
Okay. Jim mentioned 5 issues in the Stiffs appeal. I believe there are only 4. Issue number 1 is it an accessory structure? Issue number 2 is, did they provide a soils report?
Right.
Issue 3 is, did they provide federal flood elevation data?
Right.
And issue 4 is, did they provide a written soil and erosion control plan?
I had that as number 5, and number 4 was an enlarged parking area being part of the application.
That may have been, Jim, and I thank you. I don't believe that was an issue that we raised back on November 13th.
Okay.
And I just want to clarify, and I know John addressed it as well. Subsequent to that meeting, the planning board had a hearing to review the soil and erosion control plan. And the Stiffs participated in that meeting. And although the plan may not have met the letter of the law, the Stiffs were convinced that there are no ongoing soil and erosion control problems as a result of this structure. So they are no longer pushing that argument.
So the finding of fact not supported by the record when described an enlarged parking area as being part of the Jones's application is withdrawn.
That is correct.
Okay, that's all I needed to know. Thank you. I stand corrected.
No, I should have clarified that point. Thank you for letting me do so.
So there are 4 issues in the Stiffs appeal, 2 issues in the Sutton's appeal, Mr. Sutton's appeal. If I could jump in, it might be, I believe it would be quicker to address the Sutton appeal because I think that raises issues of law that resolve the issue, that resolve the appeal right up front.
That would be helpful. Thank you.
Mr. Chairman?
Yes. Mr. Bourne?
I'd like to raise an issue that affects both appeals. if the board will just relate back to the Brightside appeal, we had a situation where we had a lot that was divided by a public road, and it was very clear, and there was no argument as to whether the lot that was subject to that appeal was separate from the rest of the lot as described in the deed. In this case, I note that we have the right-of-way that Jack Sutton refers to that crosses the Jones land. And if we look at the definitions in the ordinance and we look at, I believe it's section 16, I believe it's section 16.2, or no, I'm sorry. Section 15A3 in the ordinance, a lot that is divided by a public or private road are both subject to the same condition, that the lots on the portions of a lot on either side of such a road are deemed separate lots. And that requirement stems back, I believe, in the 1970s. And it's been part of the shoreland zoning ordinance all the while. And I think a finding that the planning board failed to make was whether this is in fact a private road. We know it's not a public road because the Sandy Cove Road is a private road. It probably is not a driveway. Hence, it's probably a private road. And if it is, then I believe almost all of the dimensional considerations that have been applied to the Jones permit are subject to question, because the total lot area is not going to be the total deeded lot area of the Jones lot, but only a fraction thereof. So I raised the question of how we're going to handle that issue in going forward. Thank you.
Thank you, Richard. Jim, do you have any input on that?
There's a similar provision in the state subdivision law that basically can allow what would be one tract or parcel to be two tracts or parcels, so that you would separately subdivide. It is something that leads to a lot of debate among land use and real estate attorneys. I think it would be interesting to hear takes from counsel for all parties on what this particularly means. This is a provision 15A3, the land use standards of shoreline zoning ordinance, which states lots in common ownership located on opposite sides of a public or privately owned road shall be considered each a separate tract or parcel of land unless such road was established by the owner of land on both sides thereof after September 22, 1971. And so it's an interesting question as to how that fits in this particular instance, and perhaps the board might want to hear from counsel, from Mr. Cunningham and from Mr. Sutton as to how that should be applied here.
Thank you. Mr. Neagle?
I don't know that he has a dog in this particular hunt, but certainly if you want to ask him, you may answer.
Thank you, Chairman. I know I feel I've spoken more than my fair share, and I'd prefer not to address this issue in the Sutton appeal. Thank you.
I'm sorry, Mr. Cunningham?
Yes, I think, I don't know that it's part of the record that was in front of the planning board, but I'm fairly certain every segment of that road was established by the owner of the land on both sides. My question would be as to which segment was created when. We'd have to check the dates to see how that fits with your ordinance. I agree with Jim that it's copied from the state subdivision law, or seems to be. But I'd want to check that out for you if that becomes an issue. I'm pretty sure it was the person on both sides. It was the fellow who owned all of that land, established the road when he granted the easement. So he owned the land on both sides. But I need to check the dates of each section of the conveyance.
I think it's fair to say it was not an issue that was raised by or before the planning board. And I'm looking at the state subdivision law right now just to go back and take a look at this. That is almost identical. All parties have treated this as being one tractor parcel, one lot. It's on the assessor's records, I believe, as one lot. It's provided through here, through the record. And everyone has treated it as one lot and not as two separate lots. It's not an issue that's been raised by the parties. Certainly the board can raise an issue on its own, but that's really not something that's been argued against this. And at worst, what it would cause you to do is just send it back to be remeasured. You still would wind up having two buildings placed on one substandard lot.
Okay.
Mr.
I have
Chairman?
different numbers, but I don't think it would be a substantive difference.
Mr. Bourne?
Yeah, to Jim's points, if we go back to the experience in the Brightside case, that was a similar situation where the assessor had and the town considered those basically all one lot from a deed point of view ultimately. But the point would be in this case that because the impervious surface total area that's in the documentation is very close to 50% of the lot area that was used in calculations. And because we've got a septic system that is very close to a right-of-way, seems to me that if it is considered a privately owned road, then we may be working with incorrect data in terms of what is permitted in terms of size of structure and other points.
If we were to address the Sutton appeal first, Mr. Sutton makes 2 points. One is that the planning board did not define the road. And the other is that the septic discharge point potentially follows his property to his follows Mr. Sutton's property to his detriment. From a legal standpoint, my advice is that it's not the planning board's role to define a road. the plan has on it the easement data that was available, the center line of the road and the date of the easement and where it was recorded. That's all the information, it appears, that was available to the planning board from the deed and from the surveyor and in K&K survey. That's part of the record. The planning board has no authority or jurisdiction to define road rights, and simply was asking to have those put on for review to know where the road was as opposed to structures in other areas. It does not define those rights, and this board has no greater jurisdiction than the planning board. You're just looking to see that they do the right thing. My advice to you is that as a matter of law, the planning board did not do anything wrong in not defining that road and the road width. That's not its job. So that's one of the arguments made. And as to the other, I think it was brought up. There's a septic system that was approved. It was approved by a permit issued on February 25th of this year, and no appeal was filed. And this board has no jurisdiction over an appeal from that. So I think regardless of the lot, whether it's divided by a road, that's more an issue that if it goes anywhere, it goes with regard to the Stiffs appeal. It doesn't have anything to do with the road width that Mr. Sutton wants to find. It has nothing to do with the septic system that Mr. Sutton would like to see overturned. So my advice is that as a matter of law, it would be in order to consider denying the appeal of Mr. Sutton with all due respect, because as a matter of law, those two arguments simply aren't available. There's no relief available from this board.
Understood.
Does that help you, Mr. Bourne?
That's fine, Mr. Chair. I just want to make sure that that we don't overlook a factor that could have bearing on our decision.
Okay, thank you.
I think Mr. Neagle has a question.
Mr. Neagle? Mr. Neagle?
Yes, thank you very much. I'm sorry to jump in again. I guess with respect to the issue that Mr. Bourne raised, he may have better insight than anyone else, and I respect that. However, I think Mr. Katsiaficas would agree that because neither the Stiffs nor Mr. Sutton raised that particular issue of the possibility of there being two lots there, that issue has been waived and really is not one that I think is within your jurisdiction to consider. And we do not consider it part of the Stiffs appeal.
Thank you. Okay, Jim, I need some guidance here. Where do we go from here?
Well, I've given you some ideas as to the Mr. Sutton's appeal and how that might be disposed of. I don't know how the board feels about that. I'm not a board member. I'm your outside attorney trying to be the impartial legal advisor here. So I don't want to make decisions or tell you what to do. But as a legal matter, I think the law is is against Mr. Sutton's appeals, and if the board agrees, you don't have to take a vote tonight. You can just say, we hear you, Jim, draft up a decision that goes that way and we'll consider it at our next meeting. So I have that direction from the board.
Mr. Bradshaw?
I would offer that direction that yes, to please proceed.
Mr. Bonar?
Yes,
Okay, Jim, should we, is that good enough? Should we take a vote on that at this point?
Let's not take a vote on that yet. I'll prepare a draft decision for you all to take a look at your next meeting. You'll have that to review in advance, and and you can make your decision at that time. You'll be able to read the decision, make your findings right then and there.
Okay, thank you.
I think that's the best way to do it, Mr. Chairman.
Thank you, Dave.
I have my marching orders then. So then let's turn to the appeal here that With regard to the stiffs arguments, now there are 4 arguments. None of them involve this issue of 2 different lots. That hasn't been raised by anyone. It wasn't raised by the planning board. And what we're really trying to do is look at the ordinance as applied by the planning board. Did they make a mistake, and is it backed by evidence? I think if we look at it that way, let's stay away from this thorny private road issue that no one had raised till tonight, and focus on the 4 arguments that are in front of you. Does that make sense?
Yes, thank you.
Well, it does.
Yes. With all due respect to Mr. Bourne, it's an interesting question, but not something the parties had raised.
Well,
Mr. Bourne has so much experience and we appreciate it.
so,
Jay?
Mr. Chair, as we go through this, am I correct that are we to take the findings of fact and conclusions of law and make a decision as to whether their statement supports their finding, irrespective of the quality of the data? We're not to go beyond that, to look at what's behind the data, we're not to evaluate the reports. If they accepted a report, must we do the same?
The basic standard is there any competent evidence in the record that supports the conclusion? And so if there is, and if there are 2 different opinions on something, if there's competent evidence that supports the way the board came out, then you support it. But are the decisions supported by substantial evidence? Is there evidence in the record that supports their conclusion, or is it totally contrary? And is it contrary to law? So, for example, the first argument that Mr. Neagle made was that there's the finding of fact that this is an accessory structure is not supported by the board's record or by their interpretation by the ordinance language. We have information as to what was in the building, what its dimensions were, with regard to the other building, the primary structure, residence on the lot. You have information regarding the number of rooms and what they were, and the condition that there be no cooking, no kitchen facilities used. Is that an accessory structure or no? Is that decision that it is an accessory structure contrary to the ordinance? Is it contrary to the testimony and evidence in the record?
Dave, what do you think?
I'm kind of torn. Somewhere along the line, somebody, since we're in deliberations, I think I speak pretty freely, but somewhere along the line, somebody dropped the ball. And by the same token, there's a considerable amount of financial expense that this individual has put out. But by the same, we still have to make sure that it is done in accordance with our planning and zoning laws, and it seems to me that it wasn't followed through properly. And I think, in all honesty, I think it should be sent back to the Planning Commission, let them correct errors that they made.
But do we?
Okay. Jay?
No, I was just but are we to make a statement that we believe that they erred in that? I mean, the whole thing of accessory structure or not. I mean, the board that is charged with doing that took a look at it and they said, you take out the kitchen appliances, that they consider to be an accessory structure. Are we in a position to say, just simply, we disagree without something more substantive on which to hang our hat?
Jen, can you add to that?
You do have to point to it. You may not like the process of what went on. You may think someone dropped the ball. That would be a conclusion that I think the Stiffs would ask you to make. But that's not what you're being asked to decide here tonight. What you're being asked to decide here tonight is the planning board's decision correct as a matter of the ordinance? They follow the ordinance and is supported by the facts that were before them. And you have an ordinance that defines accessory structure. And the question is, did they make a mistake when they called this an accessory structure? In the after the fact permit with the condition that there be no kitchen appliances.
Norma?
Yeah, this is a very big issue for me. I wondered if it was even open to debate because the planning board decided and they went from there. But I agree with what Mr. Neagle has said, that this is definitely not a subordinate structure. And there were in the record testimony from the builder, the people, the Joneses, that they deemed this to be a part of their house. Also, they say the shed is a part of their house. I mean, they've got 3 houses there on one building, on one lot. And then you see what's left after they take out the appliances. It's still a kitchen, especially a camp kitchen. It's a very nice camp kitchen. And this town is left with policing this for all time. It's a burden on the town. They've set a condition on this permit that establishes a burden on the town for all time. If it were like every other structure on that road, maybe I could understand it, but it's not. It's different from every other structure on that road, according to what's been said tonight. So if that very premise is wrong, then the whole discussion that we're having is different, should be different. That's my opinion.
Mr. Bourne, do you have anything to add?
Well, I guess where I come out on this is one way to look at it is forget the fact that this was originally created as what has been called a second residence, and assume that what was being presented to the planning board was simply an application for an accessory structure for a garage and a workshop. And it was of the same size as what we're being presented with. Would the issue be anything to do with the structure not being an accessory structure? And I doubt that that issue would be raised. People might not be happy with the structure, but in terms of the ordinance, there'd be no conflict. If, on the other hand, the Joneses had decided to, rather than put bedrooms, additional bedrooms in the accessory structure, they had simply increased the number of bedrooms in the existing house, I doubt that there would have been any major issue or major flags be raised by that. It seems to me that the issue of occupancy is not addressed by the ordinance. So if you had a family of 10 or a dozen people who bought a piece of property like this, and they were still a family, there'd be no issue. seems to me that the straightforward definition of an accessory structure in the ordinance, since it has no physical limitations, that this whole issue has an emotional component that gets in the way. And I don't see that the planning board made any errors of fact in the process of any substantial nature. So I guess that's where I come out on it.
Okay, thank you. Dave, did you have, Norma?
Sorry. There is an issue with the shorefront, the length of the shorefront, if this is a second residence. It doesn't have enough frontage to have a second residence on the same property. So it does matter, in my opinion, as I see it, whether this is a residence or a garage or an accessory structure.
If I may, counsel for both parties agree this is not a residence. I think I'm not misstating that. I think I heard that from both. And the question is it an accessory structure or not?
Yeah, I need to address that, Jim. That's just a false statement. We believe this building is a second residence. We do not believe it is a dwelling unit as defined by the shoreland zoning ordinance. That's a very important distinction. This building is a residence, which means it is not an accessory structure. And whether it fits a definition for some other use is simply not relevant. Thank you. I just needed to disagree with what he told you our position was.
All right, I meant to say not a dwelling unit. That's important because the table, which talks about frontage, deals with residential dwelling units. This is not a residential dwelling unit. I think we can agree on that.
We have never argued that it was.
I understand.
We have argued that it is not an accessory structure.
Right.
Because of its size and because it has essentially the same layout as the existing structure. Thank you.
Mr. Chairman,
Mr. Cunningham?
thank you. I apologize. I believe the public hearing has ended and we're not supposed to join in your deliberations. If Mr. Neagle is going to be allowed to step in and repeat his arguments, I'm going to feel unfairly treated.
Thank you. Good point. Jay?
Mike? I wish I was a portion as articulate as Dick Bourne is, because I think that he did a nice job of succinctly describing what I was struggling to say. I think the emotional aspect of this is significant, is certainly understandable, but our charge is to approach this with a different lens, and that is the statutory one and the ordinance one. And I think in this case, I lean towards the fact agreement that it is an accessory structure.
Okay, thank you. Norma?
Because it doesn't have a kitchen? I mean, is this why we're saying, or why the planning board they said they made that accommodation or that condition to preclude that being a dwelling unit? Okay. And the Shapley case that Mr. Neagle presented argues that that actually might not be quite enough. It depends. I mean, it sounds like a very significant difference that affects the outcome of the whole process.
I would say this is a really nice building. I mean, but whether it's whether that puts it in other than an accessory structure, our colleagues who sit on the planning board actually did go take a look at it, and they came back and said, you have, and I think it was acknowledged early on that prior to the planning board's action and conditions, that it really did, we're on a line or close to a line, that by virtue of the fact that it did have kitchen appliances, that tipped the scales in a very different direction. But that, taking that out, that it does change that distinction towards the fact that it is an accessory structure.
Thank you, Jay. Jim?
Well, in a zoning ordinance, things are typically either a principal use or structure or an accessory use or structure. So your residence, your full-time, well, I'm sure some may disagree, and we'll see if what we do. But you know, your residence is your principal structure. The tool shed is the accessory structure. The garage is the accessory structure, as Mr. Bourne pointed out. Your garage might have a laundry room, or it might have a workshop, as many of us might have. Does it change from being an accessory to anything else if you put a bedroom there? That's what this really boils down to. If you have a bunkhouse, as some people were saying, where there's no kitchen facility, does that suddenly become another dwelling unit? No, because it doesn't have kitchen facilities. Does it become anything other than an accessory structure? And if so, why? It's either principal or it's accessory. That's what's recognized under most zoning ordinances.
Norma, did you have another question?
I'm not too sure of my parameters actually, but there is precedent, and for interpreting the definition, I guess, since it's not specific. Is this in the nature or the purpose of the shoreline zoning ordinance at all, to have two equal buildings on a property and defining one as an accessory structure? Is that what the Belgrade Shoreland zoning ordinance wants for the town? Is that the purpose? It says in the prelude to the ordinance that it's to preserve the character of the land. And this is very dense land use in soils that we haven't even talked about yet. I can't say, maybe it doesn't meet I agree that it's not a residence. Everybody agrees it's not a residence, but it doesn't sound like a subordinate structure to me either. And I think it's setting a bad precedent in the shoreland zone to allow a subordinate structure to look that much like the residence on the same property. I'm going to quit because I've said everything I have to say.
Jim? Yeah.
Did you call on me, Mike?
Did you have a question, Dick?
I was just going to offer a comment.
Okay.
Relative to the trials and tribulations that Norma is having. I think if the intent is to limit the interior activities in an accessory structure, the town, the legislative body, is going to have to go back and revise the definition of an accessory structure. Because as it is now, there are essentially no limitations whatsoever on what one can do inside the envelope of the structure, short of having a kitchen in addition to sleeping area and bath and garage and washroom and so forth. So I think the problem that she raises is really one of definition in the ordinance. And if we look at the definition as it's written, there is just virtually no limitation.
Thank you, Dick. What is the next thing, Jim? Do we have?
Well, I don't know which direction folks want to go in. I've heard arguments on both sides. So what's a consensus of the board? I'm not asking you to take a vote, but just for guidance, which direction is this tipping in? Is it an accessory use or is it not? Was the planning board right? Or did it make a mistake?
No, just for purposes of discussion, it is my opinion that it is an accessory structure.
It is?
It is.
Okay, and Mr. Bourne, your opinion as well?
I believe it is.
Okay. And Dave Bonar?
Yes, I believe it is.
Norma, what is your opinion?
Well, I don't know for sure, but it doesn't seem like a subordinate building on the same property to me. So I would guess I would have to say it, no. It's not an accessory structure.
Okay. Myself, I believe that it is, only because that they took out the appliances supposedly. So I guess you can read on that, Jim.
Okay, I do have a reading on that. Thank you. Next issue. Did the planning board make an error of law when it did not require that the Jones produce a written soils report under, I think it was section 15U of the shoreline zoning ordinance? This is where the planning board found that there had been a licensed inspector, had been a report on soil submitted with the septic application. And the question is whether that's sufficient as a matter of fact and whether that's correct as a matter of law. There had been a state certified soil evaluator, site evaluator, who had submitted the soils report for the subsurface wastewater disposal system. Is that sufficient to meet standard 15U?
Do you have the ordinance right there, Jay?
I'm looking for it. I've got the ordinance, but it's not laid out very well. 15U. Actually, I think I've got it here.
P is on 48.
The page
It
is
was on
oh, I see.
page 59.
Thank you. Page 59. P. the slopes. So, am I off? Yeah, I'm not muted. Mike,
Yes.
so I apologize for perhaps sounding so dense at this point, but are we being asked to take a look at the soils, and make a decision as to whether this soils report that was submitted with it is adequate?
Yes, I believe.
Well, it isn't so much whether it was adequate, it was, did the planning board make an error in allowing that to be the report?
Oh,
Did
okay.
they misunderstand or misuse this ordinance? And then is there a decision that this met the standards supported by the report?
Well, I fall back on the fact that, there is a report that has been acknowledged that it came from a state certified soil site evaluator. And it spoke to the suitability. This is certainly not my wheelhouse, but it's hard for me to find that there's an error.
Dick, what do you think?
I guess I would have a question for Jim, and that is a licensed site evaluator qualified to issue such a report? If that were the case, I think it would be a moot point. I tend to feel that they had adequate basis for the finding that they made.
Main licensed site evaluators are the people who will take a look at soil adequacy for septic systems and will look at the types of soil and whether they will support particular systems. That much I know, and I don't know anything more than that.
And I as well know a little bit about that is when they design septics, that they test the soil, they drill holes and test the soil and so forth. Now, whether or not, I don't recall if anything is sent to a specific lab, but I think they have their own qualifications that they have to meet when they design these systems. And therefore, that's why they require so much rock, so much sand, so much fill and so forth. This system hasn't even been built yet, is that correct?
Correct. I understood that it's been staked out, but it hasn't actually been.
Right, that's what it was in the, it was staked out, yes.
Right.
I guess I find that it's adequate, the report, myself. Jay?
Yeah, I think it's adequate. So, there.
Jay, do you agree? And Dick, do you agree? Norma, what's your opinion?
You're muted, Norma.
You're muted, Norma.
I'm sorry.
That's okay.
It says that at section U, it says who is appropriate to give this opinion. And this licensed professional
Soil evaluator.
is not one of the people listed, or not one of the professions listed.
It does say certified persons may include.
That's
So
true.
it's not limiting. It may include Maine certified soil scientists, Maine registered professional engineers, Maine state certified geologists. Licensed site evaluators are licensed by the state of Maine.
Because it's not just about the septic, it's about the whole property. As I understand it, the soil assessment is not just for septic, it's about the entire property and the purpose for which it's going to be used. I don't. I don't have an opinion on this yet. I have to think about it. I'm sorry.
Okay. Dave, what do you think?
I don't think that they, based on what has been said, I don't think they made an error in this regard.
So other than Norma, you'd like to think about this some more, Norma, before you give your opinion?
Yes, I would.
Okay.
Mike,
Jay?
I would suggest that, the purpose of this was not to take a final vote. The purpose of this was to take the pulse of the group. And I think that, I think we've done that.
Okay, thank you. Next, Jim.
Yes, the next one is whether the planning board made an error of law when it did not demand that the Joneses submit any information on compliance with the Belgrade flood management ordinance and relied on plans not presented to the public at its meetings. To the extent that this wades into the question of bias is something you have to raise in front of the board. You want to preserve the issue to appeal from, but that's really not for your deliberations. That's for a court. The question really is, did they meet the Belgrade flood management ordinance? Or did they meet the floodplain standards of the shoreline zoning ordinance? And is there evidence in the record to support it? Let's take a look at the decision. It's on page 2 of the planning board's decision. Item 7 will avoid problems associated with floodplain development and use. The finding was by a vote of 4-0 to 1. The board found that this standard was met based on the testimony in the record from the code enforcement officer that the property was not in the floodplain as indicated on the town's maps, and further verified this testimony by reviewing the applicable FEMA maps online. There's a statement that's been made that it's illegal for planning board members to do research on their own. I'm going to beg to differ. Only in that, in my experience, there are many towns that do not have the means to have their own town planner, and you will have planning board members do research. It's not ideal. You'd like to be able to delegate it to a planner to have that person do that research for you, but in many towns in Maine, that just doesn't happen. And so as long as they bring it back to the board and explain to the board what it is they're making a decision on, so that everybody can understand it, comment on it, and react to it. Maybe shoot it down if they think it's wrong. I think that safeguards the system. It's not a violation of the Freedom of Access Act and not holding an illegal meeting outside. They're bringing in research from the outside. So I think the question is, did they use the proper standard, and does the evidence in the record support their finding? That's the question.
Okay.
What he said. No, I agree. I would be quite concerned if a group of people got together and huddled over a website or any other document outside of a public setting. But the fact that they collected this, regardless of the source, they collected information that has not been refuted, is the FEMA maps, and they brought it to the group. It was in a public setting. The group reviewed whatever was presented and found that it met the criteria. I don't find that there's an error of law in this regard.
I believe that they used what they had for resources appropriately. Norma, what do you think?
I agree that they did use resources that made sense to me and made a decision, and they did that at a meeting, I believe. So, yeah.
Mr. Bourne?
Oh, I agree.
So there you have kind of a,
Did you ask Dave?
I have my marching orders.
Dave, I'm sorry, I forgot you.
Oh, that's all right. Yeah, I agree with everyone else. I think that, you know, they had information given to them they thought was reliable.
So the last issue is that the planning board made errors of law when it allowed the Joneses to file an erosion and sedimentation control plan after the planning board approved the permit.
Could you repeat that, please? I didn't hear you.
Sure, that I'm paraphrasing Mr. Nagle's statement. If I do a bad job of it, I'm sure he'll correct me. I want him to. That the planning board made errors of law when it allowed the Joneses to file an erosion and sedimentation control plan after the planning board approved the permit.
So Jim, could you briefly give us the evidence on this?
Well, as I understand it from the record, the erosion and sedimentation plan was brought in for the last meeting. The planning board wanted to be able to review it. Or, okay, maybe it wasn't brought in for the last meeting. I thought I understood that from what the parties were saying, but both are shaking their heads, so I have that wrong. It needed to have the erosion and sedimentation plan reviewed and approved as part of the shoreline zoning permit. So the board not only required that plan as a condition of approval, but required that it further hold a meeting and review it, which it did. And so it wasn't as though they delegated their authority to somebody to make a decision for them. They retained that authority. They issued the permit with the condition that this plan be submitted and that it be reviewed in a public meeting. And that was done. So is that illegal? Is that contrary to ordinance? Is that unsupported by fact?
Norma?
Well, that fact isn't in this record that we're looking at, so I'm not sure how we handle that, but that approved and that approval and discussion is not a part of this record that we're reviewing. And isn't this sedimentation control plan is for the building phase, which is a done deed anyway, so I'm not sure how it helps.
Well,
Okay.
I was just, looking at their conclusions. I believe we're talking about S on page, whatever this is, 3. It says, based on evidence in the record, the standard was met on the condition below requiring the submission and approval of an erosion control plan. So, I mean, in my other world, I've seen conditional licenses issued somewhat routinely. That still makes it a valid license as long as the conditions are met. If the conditions are not met, well, that becomes a different story. But if they issued a permit with conditions and those conditions were met, I guess I'm missing what the issue is. The whole package came together, and their findings of fact support that the whole package came together. And that it wasn't an after the fact, the requirement of the plan was part of the permit when it was issued, if I understand this correctly.
And boards are able to attach reasonable conditions of approval so long as they're related to standards that are within the board's purview. Erosion and sedimentation controls are within the purview of the planning board under S as noted.
Seems like we should have a note then, that we had this discussion and based on evidence that's not in the record that we're reviewing, since they followed through and did that, we have no problem with the choice they made earlier.
Since this was a decision on a condition of approval on the matter that's under appeal, would the parties have any objection to the erosion and sedimentation control plan and the decision of the planning board to approve that being part of this proceeding?
I have no objection.
Mr. Neagle?
Yeah, I definitely have an objection. This board is trying to decide if the planning board made an error on August 6th, I believe. Anything that happened after that is absolutely irrelevant, which is why it's not in the record. So yes, I do believe it's, and I'm sure Jim would agree, when you're doing an appellate work, you do not admit new evidence, which you told us we could not admit, of events that happened after the planning board decision. I'm surprised you even asked.
Well, nonetheless, there was a photograph provided today by you that was not part of the planning board record. So, you know, things happen. If they are agreed to, then the parties let them in.
False statements. That picture
Whoa,
was
time out,
exhibit.
This is,
Jim,
we are
well,
way
sorry.
beyond.
Jim is accusing me of submitting a document
no.
that's not in the planning board record.
No.
Yes, he is.
I didn't
He just
see it
said
in the
it.
record when I went through it today. All I'm saying is.
It's there, Jim.
All
It's
right.
attached to my memo.
Thank you.
That's why it's called Exhibit 16.
Thank
With
you.
all due respect, I don't think you're giving fair and impartial advice. And this is another example. Thank you.
I would just offer that it's time for us to wrap this up. I think we've gone on long enough. It feels to me like we all agreed that we were going to stop a few minutes ago. And I think that there's a degree of stress. I've been up for a long time today. I'm pretty tired. I think I would suggest that we've provided some points to our attorney to draft. I think I would suggest, Mike, that the other thing we need to do is to figure a timeline. If we have to have a decision within 30 days, I would suggest that we try to meet maybe like right after the first of the year.
Yep.
And that I would suggest, if we can set that date right now, that would be really helpful.
We want to go a couple of weeks after into January or a regular meeting day?
I would suggest I don't mean to step on our attorney's toes, but I mean, we're supposed to have a decision within 30 days of tonight.
Right.
And I would suggest that in the event that we needed, at our next meeting, we needed a little bit more time, I would suggest we look at something like that first week of January. So that would give us perhaps the second week of January if we needed a little bit more time for anything. So if Jim thinks that he can have something drafted by, I'll just toss out the 6th. And if the others are agreeable, see Mr. Neagle has his hand up.
Well, I just want to comment, you haven't made a decision. So there's no 30-day time limit on when you put it in writing. I just wanted you to understand, you can have your next meeting whenever you want to, because you haven't made a decision yet.
Oh, thank you for the clarification.
I
misunderstood. I thought that we had to have the decision within 30 days of closing the hearing.
Well, Jim could correct me if I'm wrong. I think once you've made a decision, you have 30 days to produce it in writing.
Well, once the Board of Appeals makes a decision, it's supposed to issue a written notice of decision within 7 days. But my point was, there's an ordinance that governs the Board of Appeals in Belgrade. And that requires that you issue a decision within 30 days after the close of the hearing. So that's where that comes from. Decisions by the board shall be made not later than 30 days from the date of the final hearing, and that's under your section X of the Board of Appeals ordinance for the town. I am in meetings on Wednesday, the 6th of January and the 7th. Got a Board of Appeals meeting on the 7th and Planning Board on the 6th.
Jim, if I could interrupt one more time,
Please.
the planning board could adjourn this meeting, which is a very common event, and then it would not be the final meeting requiring a 30-day deadline that you're all trying to squeeze into. And if you're worried about a 30-day deadline, I'm sure the stiffs would consent to an enlargement. Just trying to help you out.
I understand.
Sean Cunningham?
Certainly, I'd agree to, if we get to waive a deadline, that's agreeable to us. Though if I understood what Jim was saying correctly, the 30-day restriction, was it tied to the close of the public hearing, or was it?
Yes.
Yeah, so the public hearing has closed.
So you could do one of two things. We can get together on, for example, Wednesday, January 13th, and just push through. You'll have a draft decision and we could finish it up that evening and you could make your decision. Or you could vote to reconsider your motion to close the public hearing and continue the public hearing, and that would continue the 30-day deadline.
Well, I think we've already closed the hearing technically, and we've been in deliberation. So I would agree that we could do it set the next meeting for the 13th.
I agree, Mike.
Okay.
No, I agree. I think there may be a process by which we could vote to reconsider. I understand that, but I don't think that's necessary. And if the 13th works for people, let's do that.
Okay.
6 o'clock.
Same back time.
6 p.m. on the 13th.
Let me just, is Anthony still with us? Yes. Anthony, is this Zoom meeting available on that day?
Let me take a quick look. There is a communications committee meeting that evening. I mean, obviously, I think this would take precedence over that. I think we could easily reschedule that if need be. Jay serves on that committee. Would you agree with that, Jay?
I would. I'd also offer that I could give you another Zoom ID and record it and get you the recording as well if we need to.
Well, and there is one other option if the participants in this would like to have a meeting during the day as opposed to the evening time. That might be something that fits into everyone's schedule a little bit better.
Okay, can we can deliberate about that, maybe to do the daytime or the evening, whichever works for everybody, and can communicate between the parties. Does that work for everybody?
Well, if we can do it right while we've got the key people right here, if we can look at calendars, that would be.
Okay. So the 13th is at 6 p.m. Does that work for everybody?
Is daytime an option?
I'm not sure. It is for me. I don't know about the rest of the folks, but.
Fine by me.
That's fine by me. I don't care.
It's fine
Good for
by
me.
me. And I know Jeff's still here. As far as I know, they're both retired, but they may have other plans.
Yes, that's fine for me too.
Thanks, Jeff.
Mr. Bourne, is a daytime meeting okay with you?
Yes, it is.
Okay. Does anybody have a preference on time? Like
1 o'clock.
1 o'clock?
Fine.
Okay.
Is that
Okay,
okay?
1 p.m.
Was that okay with Mr. Cunningham? I didn't, sorry, Mike, I don't mean to keep stepping in.
Anthony, does that work for you for the Zoom?
Yes, sir. Then which date are we talking about at the moment?
The 13th of
Yes, sir.
January at 1 o'clock.
Yes, sir. We can accommodate that.
Thank you.
I will have draft decisions out to the board for you to look at in advance of that, well in advance, so that you will be able to think about this some more. And we should be able to conclude things that afternoon.
I have a procedural question I'd like to ask.
Go ahead, Norma.
I'd like to know if, if we need minutes for this segment or for the entire process. What is the situation? Do we need minutes for tonight's discussion and then minutes again on the 13th, or is it one meeting?
State law doesn't require minutes, but requires a record of a meeting, the record being who was there, date, time, and place, any motions, who voted in which manner on those motions. That's what's required. Anything more than that is whatever you want to put into it. I don't know what your typical approach is. That's up to you.
We do minutes for each meeting, very distinct minutes as a rule, thanks to Norma.
So you
They can
want,
be as detailed as you want to make them, I guess is my point. That's entirely up to you in your practice.
so you want the mic, right?
Yes, please.
And Norma, I'll send you the video link tomorrow.
I like that. Thanks.
You're welcome.
It's a big help.
Okay.
Okay.
Anybody have anything else? Mr. Bradshaw,
I'd like to move to adjourn,
anyone second that?
please.
Second.
Thank you.
Okay. Roll call for adjournment. Norma Blazer,
Yes.
Mr. Bonar,
Yes.
Yes.
Mr. Bruin, Mr. Bradshaw,
Yes,
Mr. Hano, yes.
thank you.
Thank you very much, everyone. Thanks, Mr. Cunningham and Mr. Neagle.